Karen forged documents and sold my house while I was deployed in Afghanistan, claiming I had abandoned the property. What she did not realize was that when I came back with judge, advocate, general attorneys, and federal prosecutors behind me, she would learn the hard way that fraudulently selling the home of a deployed service member is a direct violation of the Service Member Civil Relief Act, and the legal fallout that followed would strip her of everything she owned. My name is Steve, and I am a staff sergeant in the United States Army with 12 years of active service. I deployed to Afghanistan in March of last year for what was scheduled to be a 15-month deployment in support of combat operations. Before leaving, I took every required step to secure my property and finances, automatic bill payments, power of attorney granted my brother, and full compliance with all pre-deployment requirements. What I never imagined was that the HOA president in my neighborhood would commit multiple federal crimes by selling my home while I was in a combat zone, triggering a legal response so severe it would financially ruin her and ultimately send her to federal prison. I own a home in Riverside Meadows, a subdivision built in 2010 just outside Fort Bragg in Fayetteville, North Carolina. The area has a heavy military presence. Roughly 70% of the residents are active duty service members, veterans, or military families. People there understand deployments, long absences, and the realities of military life. The HOA handles basic services and, until this incident, had always been reasonable. For 6 years, I lived there without a single problem. My neighbors knew I was active duty, and that deployments were part of my life. Before leaving in March, I made sure everything was squared away. I prepaid 6 months of HOA dues, hired a lawn service to maintain the property, set up automatic payments for utilities and my mortgage, and gave my brother James full power of attorney to handle anything that might come up. I deployed in early March, and the mission was intense. We were operating in a contested area with limited communication access. Email was sporadic, and phone calls were rare. I occasionally managed to check in with James, but contact was difficult and infrequent. For the first several months, he told me everything was fine. The lawn was maintained, bills were paid, and there were no issues. Then in November, 8 months into my deployment, James called during one of the rare windows I had for a personal call. His voice was strained. "Steve, something is seriously wrong," he said. He explained that he had driven by my house and saw a family living there, not renters, but people fully moved in with furniture inside and kids playing in the yard. He knocked on the door, and a man answered, saying he had purchased a house 3 months earlier. I told James that was impossible. No one had authority to sell my home. James said the man showed him closing documents and explained the sale had taken place in August. According to the paperwork, the HOA sold the house for unpaid dues and abandonment. I knew immediately this was fraud. I had paid my dues in advance, and I was deployed, not abandoning my property. I told James to contact the base legal office immediately, explain that I was deployed, and report that my home had been fraudulently sold in violation of the Service Member Civil Relief Act. Military lawyers needed to be involved right away. James contacted the legal assistance office at Fort Bragg and spoke the next day with Captain Rodriguez, a judge advocate general attorney who specialized in Service Member Civil Relief Act cases. Captain Rodriguez immediately understood how serious the situation was. The Act provides strong protection for deployed service members, including protections against foreclosure, eviction, and property sale during active duty. Selling a deployed service member's home without proper legal authorization is a federal violation that carries both criminal and civil penalties. Captain Rodriguez began investigating immediately. He obtained copies of the sale documents, contacted the HOA, and uncovered what had happened. Karen Stevens, the HOA president, had filed documents with Forsyth County claiming I had abandoned my property and owed $12,000 in unpaid dues and special assessments. She petitioned for foreclosure, obtained a default judgment when I obviously could not appear to defend myself because I was in Afghanistan, and had the home sold at auction. The buyer was a legitimate purchaser with no knowledge of the fraud. He bought the property in good faith at a foreclosure auction, believing everything was legal. But the entire basis of the sale was fraudulent. I had not abandoned my home. I did not owe money. I was on active duty military service, which gave me specific legal protections under the Service Members Civil Relief Act. Karen had knowingly misrepresented facts, forged documents showing debts that did not exist, and pushed a foreclosure while I was physically unable to defend myself because I was in a combat zone. Captain Rodriguez immediately filed emergency motions in federal court to void the sale and requested investigation into possible criminal violations. He also contacted the United States Attorney's Office for the Eastern District of North Carolina to report potential federal crimes. The response was swift and overwhelming. A federal judge issued an emergency order voiding the sale and returning the property to me. The judge ruled that the foreclosure violated federal protections and was void from the start. The family that purchased the house was devastated. They believed they had bought a legitimate foreclosure property. The court ruled they were victims of Karen's fraud and would have to pursue compensation from her, not from me. The U.S. Attorney's Office opened a criminal investigation into Karen for violations of the Service Members Civil Relief Act, fraud, forgery, and theft by deception. I was still deployed, but Captain Rodriguez coordinated everything through James as my power of attorney. Ownership of the property was restored to me, and the innocent buyers were forced to vacate. Karen now faces 6 federal charges: violation of the Service Member Civil Relief Act, mail fraud, wire fraud, theft of property over $100,000, forgery, and making false statements to government officials, carrying a potential sentence of 20 to 30 years in federal prison if convicted. On the civil side, we prepare a lawsuit against her personally for fraud, civil rights violations under federal law, and intentional infliction of emotional distress, seeking full compensatory and punitive damages. 3 months later, I returned home, landing at Fort Bragg in February, 15 months after I left. James picked me up and filled me in. The criminal case was moving forward, and the U.S. Attorney had formally charged Karen with all 6 felonies. The trial was scheduled for April. I asked the obvious question, what about the HOA itself? Captain Rodriguez explained that the HOA might face limited civil liability, but Karen had acted far outside her authority. The board was fully cooperating with investigators and had already removed her from every position she held. A week after I returned home, I met with Captain Rodriguez and a full team of JAG attorneys. They had assembled a detailed, airtight case documenting every step of Karen's fraud. Sergeant Hayes, Captain Rodriguez said, what she did was bold, calculated, and blatantly illegal. She invented debt you never owed, filed false record with the county, pushed a foreclosure while you were deployed in a combat zone, and sold your home to innocent buyers. Every single step violated federal law. The criminal trial began in April. I attended every day, seated in the courtroom wearing my dress uniform. The evidence was overwhelming. Prosecutors presented the forged HOA documents, bank records proving I had paid dues in advance, my deployment orders confirming I was on active duty during the entire period, testimony from the innocent buyers describing what Karen told them, and county records exposing the fraudulent foreclosure process. Karen's attorney argued that she believed she was following proper procedures and claimed she didn't know I was protected under the Service Members Civil Relief Act. That defense collapsed when prosecutors introduced emails showing board members had explicitly told Karen I was deployed and warned her consult an attorney before taking any action. She ignored those warnings and moved forward anyway. The jury deliberated for 5 hours before returning the verdict, guilty on all 6 counts. The federal judge sentenced Karen to 12 years in federal prison, followed by 3 years of supervised release. She was ordered to pay $240,000 in restitution, the full value of my home, plus additional compensation to the innocent buyers who lost their money. But the criminal case was only the beginning. I filed a civil lawsuit against Karen personally, represented by Captain Rodriguez and a team of military legal assistant attorneys who took the case pro bono due to severity of the SCRA violations. The civil case focused on the fraud itself, the violation of my federal rights, the emotional toll of learning while deployed that my home had been stolen, and the intentional, punitive nature of her actions. The civil trial lasted 2 weeks. The jury heard testimony about the stress of serving in a combat zone while simultaneously trying to deal with someone stealing your home thousands of miles away. They heard from the innocent family who lost their savings because of Karen's lies. Experts testified about SCRA protections and how deliberately Karen had violated them. The jury returned a verdict awarding $3.2 million in compensatory and punitive damages. Karen was already serving a 12-year sentence. Now, she also owed more than $3 million in civil judgments, on top of criminal restitution. She had assets, but nowhere near enough. Her house was seized and sold. Her retirement accounts were emptied. Her vehicles were repossessed. Her bank accounts were drained. Everything she owned was liquidated to pay the judgments. Even after everything was sold, she still owed over $2 million. The court ordered wage garnishment for the rest of her life. Any income she ever earns will have a portion seized to pay the debt. The HOA settled a separate claim for $100,000, paid from insurance and reserve funds, acknowledging their failure to properly supervise Karen and stop her illegal actions. The innocent family received compensation from both the HOA settlement and Karen's liquidated assets. They were able to purchase another home, though the experience had been deeply traumatic. I moved back into my house. Once it was returned to me, the property had been well maintained by the family who briefly lived there, and there was no damage. The HOA board, now entirely new members, came to my home personally to apologize and thank me for my service. They admitted what Karen did was unforgivable and emphasized they had no knowledge of her actions until it was too late. New oversight procedures were implemented to ensure nothing like this could ever happen again. I still live in Riverside Meadows. Since returning, the neighborhood has been supportive and welcoming. Many residents are veterans themselves and were horrified by Karen's actions. The case became nationally known within military legal circles and is now used as a training example at the Judge Advocate General School to demonstrate why SCRA protections exist and how aggressively violations are prosecuted. Captain Rodriguez was promoted to major and received a commendation for his handling of the case. He later told me it was one of the clearest violations he had ever seen, and that Karen's arrogance in ignoring direct warnings made prosecution straightforward. Karen is currently serving her sentence at Federal Correctional Institution, Tallahassee. She will be eligible for release after serving approximately 85% of her sentence, around 10 years. When she gets out, she will have no assets, no home, no savings, and will spend the rest of her life with wages garnished to pay debts she will never fully repay. The innocent buyers eventually recovered financially and moved on. They sent me a letter thanking me for pursuing the case and ensuring Karen faced full accountability, saying it gave them closure. I deployed again last year for a shorter rotation. This time, I put even more protections in place and made sure the HOA board had copies of my deployment orders and understood my SCRA protections. There were no issues. The new board is professional, respectful of military members, and would never consider the kind of fraud Karen committed. I framed copies of the federal court judgment and the criminal sentencing order. They hang in my home office as reminders that the Service Member Civil Relief Act exists for a reason, and that violations carry consequences capable of destroying an entire life. Every Veterans Day and Memorial Day, I reflect on why these protections exist. To ensure service members deployed in harm's way don't have to worry about losing their homes, property, or legal rights while defending the nation. Karen tried to exploit my absence and steal my home while I was in Afghanistan. She assumed a deployed soldier couldn't fight back. She was wrong. The United States military protects its own. Federal law provides powerful safeguards, and violating those protections brings a full weight of military legal resources and federal prosecution down on those responsible. If you are a service member facing property fraud or SCRA violations, contact your installation legal assistance office immediately. Share this story with anyone who needs to understand that deployed service members are protected and that those protections are enforced relentlessly.